I want to show you guys the new lawsuit that threatens Donald Trump's controversial pick for Attorney General, the acting AG, Matt Whitaker. He replaced Sessions. Whitaker already under fire for many of his public statements that attacked the Mueller probe. Now, the state of Maryland filing a big lawsuit arguing that a federal judge can actually immediately remove Whitaker as AG, saying the appointment itself was unlawful, and asking that the judge declare that Rod Rosenstein is the acting Attorney General. For this story, I want to bring in former Watergate Special Prosecutor Nick Ackerman, and down here in Florida with me, none other than, yes, Guy Lewis, right there. There we go. There's your camera. Nick Ackerman, we're having a lot of fun. I wish you were down here, man.
I wish I was there, too. It's very cold up here.
I don't know anything about that. Let me start with you, and then we'll go to Guy. Viewers of The Beat are accustomed to Nick Ackerman saying, if there's a development that might hurt Donald Trump's approach to the law, it's a good thing and it's going places. But I want to press you, sir. Do you admit tonight that it is a long shot to get a state lawsuit here to interfere with the president's power to appoint someone?
Well, this isn't a state lawsuit. This is filed in federal court.
Federal court, but it's by a state.
Right, it's by a state, but it's very important. I mean, the issue they raised is a very significant issue. Under the federal rules, when a federal officer resigns, who's a defendant or a party in a case, the other party, it has to be replaced. And what this lawsuit is saying is that it has to be replaced with somebody who can actually be an attorney general. Otherwise, whatever actions this person takes in the course of the lawsuit are meaningless, that ultimately this person, Whitaker, cannot act as attorney general because it's a violation of the Constitution. He's a principal officer that has to be approved by the U.S. Senate. And it also doesn't comport with the Attorney General, the Justice Department vacancy law, that the next person in line would have to be
Nick,
Rosenstein.
Isn't this suit unlikely to prevail in the end in federal court?
I'm not so sure about that. I've read this brief, and it sits on pretty sound law. I think that the question is, who substitutes for Jeff Sessions? He was the prior party in this lawsuit, the defendant. So the question is the proper party now in place? It's not so obvious to me that this lawsuit is not going to go anywhere.
Okay. Let me bring in Guy Lewis. Guy, when you look at what Mr. Whitaker has said and done, he does not look like the kind of person who is prepared to fulfill the oath of the nonpartisan independent administration of this probe in the Justice Department. He would have to recant many of the things he said, which our viewers are familiar with. So that's a problem. But that doesn't mean that any suit that's filed against him is the right solution. What's your view of this case and its likelihood?
Look, Ari, I think you're right in terms of they've got a tough row to hoe up in Maryland. I know Matt. Matt and I worked together under the Bush administration. He's a good man, and he's a hard worker.
He may be a hard worker. Do you know? I know you're building to your however. Do you know why, as a good man who has a law degree, he says the court should be inferior, which is flatly contradicted by the most canonical Supreme Court precedent of Marbury?
Look, I don't know. I haven't talked to him about this specific issue, but I think he might.
Kind of a big issue.
Big issue. I think he might cite our favorite precedent, which is Hamilton the musical. Alexander Hamilton wrote years and years ago that the president should have not unchecked, but certainly broad powers to make these appointments. Yes, with advice and consent of the Senate, but we've got an unusual situation here where there's a vacancy. And I think overall, Ari, the Supreme Court, who may decide this case, would defer to the President of the United States.
Nick, I feel like what Guy is saying is enough to make you as mad as if somebody taxed your whiskey.
Well, that could be. But I really think that if you read the appointments clause of the U.S. Constitution, it is absolutely clear that the Attorney General has to go through a confirmation process with the U.S. Senate. You can't just appoint anybody in the Department of Justice who has not been confirmed to go into the acting position. Also, you've got a law that's been around for 100 years that basically sets up the line of succession in the Department of Justice. It doesn't mean you can take some low-level assistant like Whitaker and throw him into this position to make momentous decisions that affect our everyday lives, our Justice Department, how the laws are enforced. This is the chief law enforcement officer of the United States. This is somebody that has to go through the Senate confirmation. And what Trump obviously did here was to try and avoid that. He just tried to pick somebody who he thought would give him a get-out-of-jail card free. And that's what he did here. And I think it's so obvious that this is a prime case. If the Supreme Court is really going to make the Appointments Clause of the U.S. Constitution mean something and interpret it in terms of the succession law for the Department of Justice, this is the case.
Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.